We love Wednesdays. Because Wednesday is the day we get to do civil procedure. That's right. Good. So if you know what class you're in, that's good. Progress is being made. Think about it. You're almost done with your first month of your second year of law school. Soon you will be halfway done with law school, right? Like 2 more months and you'll be halfway done. Isn't that nice to think about? Isn't that nice? No, it's not nice to think about? No? Because then what? You're scared of what's going to happen afterwards?
Yes.
That's the easy part. Because you will have all of the skills that I've given you in this class. So your career is going to be so easy. Your professional life is so easy. You'll have a tremendous leg up on all of your colleagues and everyone else who practices law, because you will know how to put together something like this motion to dismiss, which everybody put together between Friday and today, right? Everybody did that, right? Plenty of time to do something that's relatively easy, right? And you're okay in here, and this is true of all motions, by the way, not just motions to dismiss. This is basically how they're laid out. You have your case style. Make sure to put a title of your motion on there so the court knows right off the bat what they're looking at. Right? The basis of the court's ability is sometimes I've said statement of jurisdiction in here, but you don't have to put a formal statement of jurisdiction down. You just tell the court what gives them the authority to do what you're asking them to do. In this case, that's Rule 12. Right? Rule 12 lets the court shortcut the litigation if they want to, right? Give them some facts. Doesn't have to be much. Especially in something like this, you're saying, all right, well, we're accepting all the plaintiff's facts as true, and even if we accept them all as true, the defendant still wins. Some law. I saw a couple of early drafts on Friday that cite no cases and no authority and no nothing. Is that the kind of thing you want to give to a court? No. No. Are there occasions where you can get away with filing a motion that cites no authority whatsoever? Yes. In reality, maybe. Should you? No. Right? Give them some authority, especially on something that is a dispositive motion, right? Something that makes an actual difference in the case. Then you got your signature block and your certificate of service, okay? So to kick things off, let me see what you've got, okay? Bring them to me one at a time. The rest of you can go about your business. And once you've brought them to me, you can sign in for the day. And we'll make sure that we're on track for these things, yeah? Bring me what you've written in your groups.
And then we're done. Oh, hallelujah. If you say no again, he might hear you.
Yeah, and so when you're talking about standard of care, what are we talking about? Torts specifically. Medical malpractice, right? So there's an element here. There's an element here of medical malpractice that you could rely on. Do you just jump in here and sue whoever the jail doctor is, find out who the jail doctor is, and file a lawsuit for medical malpractice? Do you get to do that? What complicates that? Why can't you do that? Immunity is one. Immunity is one big thing, right? This is still a state actor in some way, shape, or form. So you're still going to have some kind of immunity problem. You can't just jump in and sue state actors without jumping through a few more hoops ahead of time. And you can't just jump in and sue doctors without jumping through one very important hoop, which is what? Any doctor, right? Any doctor. Or any professional. Yeah.
Finding an expert witness.
You gotta have an expert. You gotta have an expert. There's somebody that's worked at a plaintiff's firm, right? Gotta have an expert before you just run in and sue a doctor, even if it seems really, really bad. in these kind of cases seem really, really bad. But again, how uncommon are they? Is it really professional malpractice? Does it really violate the standard of care? And is the doctor really responsible? How do you know any of that stuff? You don't, right? You don't. You have to have an expert opinion. Bonus round. Besides professional malpractice, what's the cause of action? Maybe we got professional malpractice. What do you have against the jail? Huh? What? I heard it.
Cruel and unusual.
Cruel and unusual punishment, yeah. Maybe something akin to that, right? Cruel and unusual punishment falls under what constitutional provision?
The Eighth Amendment.
The Eighth Amendment. The Eighth Amendment, right? The Eighth Amendment only applies to people who have been convicted of a crime. And if you're in jail, maybe you haven't been convicted yet. Maybe you're just waiting to get convicted of something, right? And so it's not Eighth Amendment, it's 14th Amendment. But then, here's the civil procedure question. Assuming we file the suit under the 14th Amendment, do you just go to the federal court and say, well, this is federal question jurisdiction because it arises under the United States Constitution. So I'm going to sue under the United States Constitution. Is that how you do it? You draft a complaint based upon the United States Constitution and say, I'm entitled to damages based on violations of the United States Constitution? Is that how you do it? Say it louder.
Don't you need like a statute or a regulation that the jail should have been following and violating?
You have to have something, not a statute or a regulation that the jail should have been following. I mean, I think you're on the right track, right? You can sue for a constitutional violation, but you don't file suit. Here's the procedure part of it. You don't file suit under the United States Constitution. Because the United States Constitution, what is the United States Constitution? Those of you that have memorized every word of it, I'm sure it's many of you. What does the United States Constitution say about whether or not you can file suit in a court of law to vindicate provisions of the United States Constitution? It says nothing. That's right. Nothing. Right? The United States Constitution does not say, if anybody has their rights violated under this document, you get to file suit in a court of law. So you have to find something that does that. Okay? You don't get to just file suit. Same goes with the Kentucky Constitution. You have a violation of the Kentucky Constitution, you just go file suit under the Kentucky Constitution? No. Right? No. You have to have a statute, some sort of authority that allows you to bring that suit in the first place. Yes?
That seems like a very dangerous thing to do, only because if there's not a law like codified for a certain type of breach, but that breach does violate the Constitution, there's no way you can get into the federal court at all because there's no statute to back you up.
And in fact, we'll talk about the federal Constitution in a minute, but if your rights have been violated under the Kentucky Constitution or under the Indiana Constitution, and you say, I am entitled to damages because my rights have been so egregiously violated under the Constitution, the state Constitution, can you get damages for violation of the Kentucky Constitution? Can you get money damages for that? Who knows the answer? Who wants to guess the answer? No. No. There's a statute that allows you to get declaratory relief, which means you can get a state actor to stop doing the thing that violates the Constitution, but getting paid, getting your attorney's fees, nope. Not going to happen.
That makes no logical sense.
It does if you're the government and you make the rules. And you'd rather not have to pay out to aggrieved plaintiffs. Under the federal Constitution, there's a thing called 42 U.S.C. 1983. When people talk about 1983 litigation, which you will hear every now and then, many of the cases that you read in your con law class are 1983 cases. Okay? That's how you get a constitutional provision into the federal court. You file it under 42 U.S.C. 1983. But if it were not for that statutory provision, which was written into the law right after Reconstruction, 150 years ago, right? If it were not for that statutory provision, which would never pass today, you have no recourse for violations of your federal constitutional rights and Article 3 courts. Okay? Questions about that? You have to have a vehicle to get into the point. The procedural point is you have to have a vehicle of some kind to get into the court in the first place. Okay? You can't just file as a matter of federal common law. That doesn't work, not for violations of the Constitution. All right, so your motion to dismiss, we already talked about. News, we already did. Motions for judgment on the pleadings. Boy, this is exciting, isn't it? Did you guys read Rule 12C? Isn't that helpful? 12C. There it is. The shortest little piece of rule that you'll read all semester long. After the pleadings are closed, but early enough not to delay trial, the party may move for judgment on the pleadings. Simple, right? Easy. Not very helpful. Right? So what is this thing? You don't see these in the wild very much, or at least I haven't seen them in my practice very much. And the lines are not exactly clear as to when you ought to be using this versus a motion to dismiss or a motion for summary judgment. And indeed, when you see these filed in the wild, you'll see a lot of muddling by parties between motions for summary judgment, motions to dismiss, and motions for judgment on the pleading. But again, I have not fielded many of these in my career, and I've certainly not drafted very many. The main way that I think the drafters of the rules want it to be used is like a 12b6 motion for the plaintiff. So if you, and we're jumping ahead here, let's think about where we are in our imaginary case. The complaint has been filed and served, and there's a motion to dismiss that was filed, let's say, and the motion to dismiss, the defendant loses the motion to dismiss. And so the defendant now has to answer the complaint. The defendant answers the complaint, and then you as the defendant have made the egregious mistake of not putting any affirmative defenses into your answer or making some other critical mistake in your answer. Right? Admitting to everything that the plaintiff says in your answer, but still saying that they're not entitled to relief. Something dumb like that. We'll talk about that more when we get to answers. There's a critical mistake in the answer, and as a result, the plaintiff looks at it and says, well, I think I'm entitled to judgment on the pleadings. I should just win. They admitted everything I said in the complaint. Why not? And there's no affirmative defense like immunity or statute of limitations or whatever that shows up in the answer that would keep me from being entitled to relief. So you make a motion for a judgment on the pleadings. Okay? Your introductory problem explains it. Let's look at this guy here. This is a plaintiff's motion for judgment on the pleadings, and it happens in the context of an action under the Freedom of Information Act. And I'll post these later. Basically what it says, and this is just to give you an example of how this works, basically what it says is that plaintiff filed a complaint saying we asked for these records under FOIA, and the defendant didn't give us the records under FOIA, and then the defendant files an answer that says, yeah, we didn't give them the records under FOIA, and also left out affirmative defenses that say why they're entitled to not give them the records under FOIA. And so the plaintiff then says, well, we get to have a judgment. Right? Why are we going to litigate this whole thing? Why go through discovery? Why do all this boring litigation stuff? Right? Plaintiff's prima facie case, answer to the complaint concedes plaintiff's prima facie case, pleads no justification, for their failure to respond within statutory time limits and offers no basis for withholding the records that the plaintiff seeks. Okay. If that's true, the defendant has screwed this up. Okay. So they're asking for a judgment on the pleadings. Another example is this one here. Defendants, and this is how these things get muddled up. Defendant's motion for judgment on the pleadings and alternative motion for summary judgment, whatever, just get rid of the case, Judge. Okay. That's a lot of times the way you see these pop up, is that we're not sure what the procedural vehicle ought to be to get rid of this case, but here you go, motion for judgment on the pleadings. Okay. And there could be strategic reasons to do that. Like say, for example, some courts don't want you to file more than one motion for summary judgment if you're the defendant. Right? You get one bite at the apple for summary judgment. There's nothing that says that, by the way, in the civil rules, but in the local rules, they might say you only get one bite at the apple of summary judgment. So you better have a really good reason to file a motion for summary judgment, a second motion for summary judgment, or you're going to get sanctioned. Well, the motion for judgment on the pleadings then lets you do this, basically make a motion for summary judgment early, and then you can file your actual motion for summary judgment at the close of all discovery. But generally speaking, you're talking about a statute of limitations issue. Could this be brought in a Rule 12b motion? Yes. 12c? Sure. Motion for summary judgment? Also yes. The defendants have multiple opportunities baked into the rules to get rid of these cases. See how it works? Easy, right? Can you do it? Here's the scenario for the day. Go away.
All right, bro. I'm gonna send you a Google Doc.